Hello friends, welcome back to India for IAS. This is Manjunath Mudod. Topic of this video is Electoral Bond Scheme. This topic can be studied under GS2 paper election related topics. In this video, we are going to study about what are electoral bonds, why electoral bonds introduced and what are its purposes, mechanism of working of electoral bonds, why it is in use recently, and challenges in the Supreme Court with respect to electoral bonds, concerns raised by Election Commission of India with respect to electoral bonds, RBI objections to the electoral bonds, and government's defense of the electoral bond scheme, and recent Supreme Court verdict with respect to electoral bonds, and a prelims practice question based on the topic. Recently, Supreme Court of India struck down the electoral bond scheme, and it said that electoral bond scheme is unconstitutional as it violates the fundamental rights of the citizens, and also it violates the few of the statutes in India like Right to Information Act. Before we move into the electoral bond scheme, first we will analyze few factual information related to political party funding via electoral bond scheme. So, party-wise funding through electoral bond scheme for the period 2017-18 to 2021-22 is given as follows. The total funding received in this period is 9,208 crore via electoral bonds. Out of this, 5,271 crore received by BJP party and 9,052 crore received by Congress party, 767.88 crore received by TMC, and 622 crore received by BJD party, 431.50 crore received by DMK party. So, by analyzing these factual information, we can say that more than 50% of the funding via electoral bond scheme went to BJP party, and remaining less than 40% it is received by remaining political party in India. As per ADR, that is Association for Democratic Reforms, BJP received 1,300 crore in the year 2022-23 via electoral bonds, and Congress received 171 crore via electoral bonds for the year 22-23, and other parties like Samajwadi Party received 3.2 crore and TDP party received 34 crore via electoral bonds for the year 22 and 23. Analysis of this data shows that disproportionate amount of money went to a single political party via electoral bonds. This is one of the reasons the scheme got criticism from political experts and opposition party leaders. Now we will understand what are electoral bonds. Electoral bonds are financial instruments and they are similar to promissory notes, also called as bearer bonds. There are two kinds of bonds. One is bearer bond, another one is registered bond. In case of registered bond, the money can be encashed by only that person in whose name the bond is registered. Whereas in case of bearer bond, whoever holds the bond, he can encash the money. In the same way, electoral bonds are bearer bonds, and which political party holds that bond, that party can encash the money associated with that electoral bond. As per the provisions of the scheme, only Indian citizens and companies can purchase the electoral bonds, that too after complete KYC compliance. These bonds can only be purchased from authorized branches of the State Bank of India. The bonds are available in following denominations, that is 1000, 10,000 rupees, 1 lakh, 10 lakh and 1 crore, and multiple of these denominations. The bonds can only be purchased to KYC compliant account and can be donated to political party of their choice, and the donors' names and details are not mentioned on the bonds. So this makes the donor's name completely anonymous. And this is one of the reasons the electoral bond scheme got opposition from legal experts, RBI, Election Commission of India, and opposition parties. One more contentious issue with respect to electoral bonds is there is no limit on the number of bonds a person or a company can buy and donate to a political party. Moving on to its introduction and purpose, the electoral bonds introduced in the year 2017 by then Finance Minister Arun Jaitley in the budget session, and it was launched via notification in the year 2018. The objective of the bond is to increase transparency in the political funding. So in order to introduce this bond, government amended several legislations, that is Representation of People Act, Companies Act, Income Tax Act, Foreign Contribution Regulation Act. Government was of the view that there is lot of corruption in political funding and there is an excess between criminals and politicians, and there is a channelization of black money into political funding. So in order to reduce this corruption, government wanted to increase the transparency in political funding, so it introduced the electoral bond scheme. Coming to the mechanism of working of electoral bonds, so all political parties cannot entitled to the electoral bonds. Only those political parties which secured at least 1% of the votes polled in the recent elections are allotted verified accounts by the Election Commission of India for depositing the bond amounts in their respective accounts. After the purchase of electoral bonds, the political party should encash the bonds within 15 days of the purchase. For example, if a person A he purchases electoral bonds on 1st Jan and he donates the electoral bonds to XYZ political party. So this political party should encash the bonds within 15th of Jan. If it fails to encash the bonds within 15th of Jan, then the money directly goes to the Prime Minister's Relief Fund. So the window period available to encash electoral bonds is only 15 days from the date of purchase. The bonds are available for purchase at the beginning of every quarter, that is 1st Jan, 1st April, 1st July, and 1st October, and also additional periods as specified by the central government during election years. Now we will try to understand why such a novel or innovative instrument called electoral bonds, which intended to reduce the corruption and increase the transparency in political funding, had been challenged in the Supreme Court. There were two petitions against the electoral bonds in Supreme Court. One is joint petition by Association of Democratic Reforms and an NGO called Common Cause. Another petition by Communist Party of India. Now we will discuss what were the arguments of the two parties which challenged the electoral bond scheme in the Supreme Court. Before electoral bonds, the corporate companies can donate only 7.5% of their net profit to political parties. Government amended Companies Act to introduce electoral bond, and it removed the 7.5% cap, and it said that corporate companies can donate unlimited amount to the political parties. And one of the feature of electoral bond scheme is the donors' identities kept anonymous. The petitioners in the Supreme Court argued that these two clauses have created unlimited political donations and anonymous funding by Indian and foreign companies, leading to widespread corruption in electoral funding. This anonymous clause also violates the citizens' right to know under Article 19(1)(a) of the Constitution. So, in essence, this clause violates the fundamental rights of the citizens. Also, removal of this 7.5 percentage ceiling on net profit to the political parties exposes the Indian political parties to the international lobbyist. Why? Because certain foreign companies which have subsidiaries in India, they can fund political parties in India and they can influence the Indian politics. So earlier we have studied that government amended the Companies Act 2013 to introduce the electoral bond scheme. One of the clause in this amendment is it exempts the companies from disclosing the political party contributions. So this increases the opacity in political funding. So this also creates the undue benefits to such companies which are funding political parties which are in power. Government also amended Section 29C of the Representation of People Act 1951. Through this amendment, government gave exemption to the political parties from informing the Election Commission of India about the details of the contributions made through the electoral bonds. It means political parties no longer required to inform the Election Commission of India regarding the contributions, that is money received through electoral bond scheme. In essence, these two clauses hides the donor's identity and receiver identity. So the donor is not in obligation to disclose his political contributions, and the receiver political parties are not required to inform the Election Commission of India regarding the funding received through electoral bonds. So these two clauses in essence creates the opaqueness in political funding, and it impacts the transparency in political funding. So this complicates the detection of illegal donations to the political parties. One more key contentious issue regarding the electoral bond scheme is that the key statutes, that is Companies Act 2013, Representation of People Act, Foreign Contribution Regulation Act, these were amended and implemented through money bill route, that is under Article 110 of the Constitution. This bypasses the scrutiny of Rajya Sabha, where the ruling party, that is BJP, lacks majority. The petitioners argued that the whole process of passing the electoral bond scheme via money bills is undemocratic, as it evades the scrutiny by Rajya Sabha, and it is also unconstitutional. The Ministry of Law and Justice also approved the bypass strategy despite raising concerns by opposition parties and legal experts. Now we will discuss the concerns raised by Election Commission of India with respect to electoral bond scheme. The Election Commission of India said that the anonymity clause in electoral bond scheme could facilitate foreign corporate interference in Indian politics. See, these companies can influence the politicians and political parties in India. They dictate the terms in their own interest. So this could also undermine the transparency in political funding, and it will lead to the high level of corruption in political funding. So these are the concerns raised by Election Commission of India with respect to electoral bond scheme. Election Commission of India also said that amendments in key legislations like Corporate Act, Representation of People Act, so these increase the anonymity of the donor, that is corporate houses and individuals who are donating to the political parties. This anonymous clause can enable in creation of shell companies only to make donations to the political parties. So coming to shell companies, these do not lack any genuine businesses. They are created only to convert black money to white money, or to fund political parties, or for money laundering purposes. They are not into genuine business. The introduction of electoral bond scheme also made the Election Commission of India guidelines redundant. Before the introduction of electoral bond scheme, the political parties are mandated to report the contributions received, and they should supposed to submit audited annual accounts, and they are supposed to provide election expenditure statement to the Election Commission of India. Now they no longer required to submit all these details to the Election Commission of India. So these are the few concerns raised by Election Commission of India with respect to transparency in political funding, and also with respect to electoral bond scheme. Also, Election Commission of India opposed the amendment to the Representation of People Act, which allows the political parties to skip the recording donations received through electoral bonds. So this is a major setback to transparency in electoral funding. Election Commission of India gave a call for selective donor criteria. So it urged the ministry to permit only those companies which are in profit with a credible track record for political funding via electoral bonds. And this was intended to ensure accountability and transparency in political funding. Now we will study the concerns raised by RBI, or RBI's objections with respect to electoral bond. So RBI said that the electoral bonds are opaque financial instruments. The anonymity clause in the electoral bond scheme could be exploited for money laundering purposes. RBI further said that electoral bonds could further increase the black money circulation, money laundering, and cross border counterfeiting and forgery in electoral funding. RBI highlighted few issues like electoral bonds are bearer bonds, that is, they are transferable like currencies. So, this and the anonymity clause in the electoral bonds can be potentially exploited for illicit purposes like money laundering and channelization of black money into political funding. These kinds of anonymous transactions hinder the compliance with Prevention of Money Laundering Act 2002. This creates more challenges to the enforcement authorities in implementing the Prevention of Money Laundering Act. So, in order to avoid such issues, RBI also suggested alternative methods. If government wants to reduce the corruption in electoral funding and if it wants to increase the transparency in electoral funding, it can go for methods like checks, demand drafts, or electronic or digital payments methods, which are more than sufficient enough to curb the corruption and increase the transparency in political funding. So these are the arguments put forward by different parties against the electoral bond scheme. Now we will try to understand how government defended the electoral bond scheme in the Supreme Court. Government said that electoral bonds introduced to enhance the transparency in political funding. Further, it said that bonds can only be encashed by eligible political parties through authorized bank accounts which is registered with the Election Commission of India. The government also said that the bonds do not bear the name of the donors and receiving political parties. Instead, it has a hidden unique alphanumeric serial number for security purposes. Attorney General in the Supreme Court argued that citizens have the right to know about the candidates' criminal backgrounds and they do not have any right to information regarding political parties' funding. He also objected to the judicial review power of the Supreme Court and he said that the court cannot scrutinize the state policies and should not suggest the alternative measures to the existing policy initiative of the government. Friends, can you mention the constitutional provisions and articles which talk about directly or indirectly with respect to the judicial review of the Supreme Court? Attorney General also talks about doctrine of separation of powers and he says that assessment of the any new law or legislation and its effectiveness should be left to the public and parliamentary debates and the judiciary should not intervene in these matters. Through this argument, the Attorney General saying is that the Supreme Court, the apex court of India, should respect the doctrine of separation of powers. So these were the government's arguments in defense of electoral bond scheme in the Supreme Court. Now we will study the Supreme Court verdict with respect to electoral bond scheme. The electoral bond scheme case has been pending in the Supreme Court for over 8 years. The Supreme Court on October 16, 2023 referred the electoral bond scheme case to the Constitutional Bench consisting of 5 judges of the Supreme Court. Then what is the rationale for referring the case to the Constitutional Bench or larger bench of the Supreme Court? So the rationale is that as per the Article 145 Clause 3 of the Constitution, it mandates that the cases involving substantial questions of law relating to the interpretation of the Constitution should be heard by a bench of at least 5 judges, and this bench is also called as Constitutional Bench. Now we will study the Supreme Court verdict with respect to the electoral bond scheme. So the first issue addressed by Supreme Court is issue 1, that is whether the electoral bond scheme violates the right to information under Article 19(1)(a) of the Constitution or not. The court said that electoral bond scheme violates the right to information which is guaranteed by freedom of speech and expression under Article 19(1)(a) of the Constitution. The Supreme Court gave following reasons. The court said that information on political party funding is vital for voting as because voters have right to know about the political party funding. So it also said that economic inequality leads to political inequality because of the association between money and politics. For example, consider two persons A and B. A has the ability to donate to political party XYZ via electoral bonds and B doesn't have ability to donate. So by doing donation to the political party XYZ through electoral bonds, this A can influence policy in his favor. So the political party, when it comes to the power, this can frame policies with respect to or in favor of person A, whereas the voter B, he is unable to fund to the political party, and the party, when it comes to power, there are every chance that it doesn't make policies in favor of the we. So this creates this economic inequality leads to the political inequality because of the association between money and politics. The court also said that this association between money and politics can also create the potential for quid pro quo arrangements, that is, mutually beneficial arrangements between the legislators and the one who is donating fund to the political parties. The second issue addressed by Supreme Court in the judgment is legitimacy of curbing black money in electoral funding and restricting the RTI Act with respect to that. So the court said that RTI can only be restricted based on reasonable restrictions that are mentioned in Article 19(2) of the Constitution. And this Article 19(2) of the Constitution does not include curbing black money as one of the reasonable restrictions for right to information. The court further asserted that even though curbing black money is legitimate, the scheme's restrictions are disproportionate with respect to curbing black money and right to information. The court also said that if government wants to implement any reasonable restriction with respect to fundamental rights, it should satisfy a proportionality test as it devised in the K.S. Puttaswamy case. The third issue addressed by Supreme Court is justification for infringement of the RTI in order to protect the donor privacy. That is, to what extent the anonymity clause mentioned in the electoral bond scheme is justifies as it violates the right to information of the citizens. The court said that donor privacy also includes the political affiliation as per the Puttaswamy judgment with respect to right to privacy. And court also said that this lack of this privacy could lead to the voter surveillance and disenfranchisement in the political process. The top court also divided the financial contribution to political parties into two categories. One is to support the political party and another one is to for quid pro quo arrangements. That is, quid pro quo arrangement means mutual support between donor and receiver. Further, the top court said that right to informational privacy, as given in Puttaswamy judgment, extends to those political contributions which are genuine in nature, not to the ones which are involve quid pro quo arrangements. By this logic, the top court said that justification for infringement of the right to information to protect the donor privacy does not extend the quid pro quo arrangements, and the court held that this infringement of the right to information is unconstitutional. The fourth issue addressed by Supreme Court is constitutionality of the unlimited political contributions by companies. Earlier, we had studied that government had removed the only 7.5% of the net profit can be donated to political parties. So this cap was removed by the government to introduce the electoral bond scheme. So the top court said that unlimited political contributions by companies are unconstitutional. Why? Because the companies can be either in profit or in loss. So by removing this ceiling clause, the government had made that the companies which are in profit and which are in loss both can donate for political funding. So there is a logic that the companies which are in profit, they can donate to the political funding. So how can the company which is in loss, they can donate to the political funding? So this creates issues like money laundering and black money circulation in political funding via shell companies. The court also said that companies have higher ability to influence the politics. So their unlimited funding to the political parties can influence the nature of politics in India. So this may disproportionately affect the common people. So through this logic, the court held that unlimited political contributions by companies is unconstitutional in nature. So this is all about the Supreme Court verdict on electoral bond scheme. So here we have provided one prelims practice question based on the electoral bond scheme in India. So go through the question. Here, this question contains 5 statements. Go through all the 5 statements and select the correct answer. Comment your answer in the comment box. The detailed answer for this question and the detailed notes of the video is available in the PDF handout. To download the handout, join our Telegram and WhatsApp channel. Thank you for watching. See you in the next video. Till then, happy learning.